Former President Donald Trump is back in the news. Although, did he ever really leave? Anyway, this time it's over 3 lawsuits he filed this week against Facebook, Twitter, and Google/YouTube over his continued deplatforming from all of their social media platforms. In this video, we're going to go over some of the highlights of those complaints, as well as some of the hurdles that Donald Trump is going to need to overcome in order to be successful. Be sure to stick around until the end so you can get the full picture. Coming up on Legal Bytes. Hey everyone, welcome to Legal Bytes. I'm Alita, I'm a lawyer, and on this channel we explain the law one bite at a time. So really quick before we get into it, we are on a mission to get to our first 10,000 subscribers. We're more than a third of the way there, and in the last year of uploads, we've gotten pretty far, but we're not quite there yet. So if you haven't already and you're enjoying the content on this channel, be sure to hit subscribe and hit the notification bell so you can find out when the next video is uploaded. Anyway, let's get into it. So the first thing to note here is that these 3 lawsuits are not individual lawsuits, but rather class action lawsuits. And Donald Trump is seeking to be the class representative of the class. So because of that, there are some additional requirements that need to be met in order for this lawsuit to be successful on top of the normal pleading requirements of any lawsuit. One of those is that the class needs to be defined. In other words, the court needs to be able to take a look at pretty objective criteria in order to define what people would be in, what people would be out, and to do that in a way that's efficient, basically. Because of that, the definition of the class needs to be pretty tight. And one of the first things to look at in any class action complaint is that definition. In this particular case, there isn't really a definition of the class. The most that we get is basically a generic description of people whose social media accounts on these various platforms have been curtailed or limited in some way by the social media platforms themselves because of the individual's expressions of conservative ideas. And this is something that may actually become a source of challenges to these complaints. For one thing, normally what we're looking for is at least a time period for when those violations may have occurred, usually in the last 2, 3, or 4 years. Now, another section that's kind of missing from these complaints is a description of the putative class representatives and a laid out argument for why they would be a good representative of the class. Particularly because these are filed in federal court, and by the way, arguably in the wrong court because they were filed in Florida, and the terms of service for all of these companies require that people file lawsuits in California. But anyway, aside from that, regardless, we're in federal court, which means that Federal Rule of Civil Procedure, Rule 23, comes into play. And that basically gives the requirements for a class action case. And a big part of those requirements comes down to 4 elements. Those are numerosity, commonality, typicality, and adequacy of representation by the class representative and his or her attorney. Numerosity means that there basically have to be enough people in the putative class to make it worthwhile to put them together into a class. Generally speaking, if there are at least 40 people in the class, that's usually considered enough for numerosity. Commonality means that the main issues of the lawsuit have to be common to all of the members of the class. And the answers to those legal questions have to be pretty common across the board as well. In other words, it can't involve a fact-specific case-by-case analysis. An example of a situation that wouldn't meet the commonality requirement would be a racial discrimination case in employment where people have very individualized fact patterns. Now, typicality has to do with the class representative, and basically that means that their situation has to be typical of other class members. In other words, the class representative can't have a particularly unique fact pattern that would set them apart from the rest of the class. And finally, there's adequacy of representation by the class representative and by his or her attorneys. As to the class representative, they basically just have to make sure that they don't have any conflict of interest in the litigation. In other words, no financial interest in the company that they're suing or anything else related to the defendant that could be impacted by the lawsuit. And second, his or her attorney has to have enough experience in class actions and in the subject matter involved in the class action in order to make them adequate counsel. Also, on top of those 4 requirements, there has to be some kind of a showing that using a class action as a judicial method is better than litigating separately. One example of this would be arguing that one case would affect the outcomes of all of the others. Another common argument that's used in class actions is that litigating separately would be too costly relative relative to the damages that the plaintiffs could hope to get individually, but pooling them together into a class makes it much more feasible for them to be heard. Anyway, in these cases, I actually couldn't find any of those elements in the complaint. And even if I did, I'd be very concerned about the typicality element if Donald Trump is going to be the class representative. And that's because his situation is actually quite unique in comparison to all of the other people that have been deplatformed in some way or another. And that's considering, given his status as president and the relative level of power and the relative context of his deplatforming when it happened, although it's continued now that he's a private citizen, it's still a very unique situation in comparison to all of the other people who are likely to be putative class members. Okay, so hi. But even if these lawsuits fail as a class action case, that doesn't mean that the lawsuit will go away. Specifically, they could continue on as individual lawsuits filed by the named plaintiffs. So in that case, could they be successful? Well, first we'll get into what it is that they were claiming and asking for and why, and then we'll get into some of the hurdles that they face. So basically, the lawsuits are asking for two things. Are you bored? First, they're asking for the court to determine that the defendants violated their First Amendment rights. And second, they're asking for injunctive relief, specifically for the courts to determine that Section 230 of the Communications Decency Act is unconstitutional. Okay, so let's get into the First Amendment issues first. As a default, your First Amendment rights are guaranteed against the government. Basically, that means that you can only sue the government for a First Amendment violation. You can't sue a private individual or a private company, and all three of these defendants are private companies, and they have their CEOs listed as private individuals. Although the complaint calls them public forums, it's important to note that they are nonetheless private companies, and the CEOs that are listed as individual defendants are also private individuals. Now, there is an exception to the rule that only the government can be sued for First Amendment rights, and that exception is where the private individual or private entity is acting as a state actor. Now, in order to prove that a private individual or a private entity is acting as a state actor, the plaintiff has to show that there is some sort of a conspiracy between the government and that defendant. And that conspiracy has to be intended to deprive others of their constitutional rights. To prove that a conspiracy exists between the two, the plaintiff has to show that there's some sort of an agreement or a meeting of the minds between the two. To be liable, the two parties don't necessarily need to know all of the specific details of the plan, but they basically need to be in on what the common goal is. But the plaintiff has to allege more than just conclusory language that there exists some sort of a conspiracy. For example, evidence showing that police officers failed to exercise independent judgment has been found by the courts to support an inference that there was a conspiracy between them and a private party. To be a little more specific, this includes a situation where police officers have an agreement with a shopkeeper where the shopkeeper identifies people to be arrested and the police officers just comply with that. Now, in these particular cases, the plaintiffs here point to several things to show that there's some sort of conspiracy or collaboration between the government and these social media companies having to do with COVID-19 and other content on social media platforms around that time. For example, in the Facebook lawsuit, the complaint highlights the emails that were produced to the public recently between Dr. Anthony Fauci and Mark Zuckerberg. In those emails, they talk about setting up an information hub for COVID-19, as well as a common aim to prevent the spread of misinformation on COVID-19 and the pandemic generally. But one problem that arises out of that particular point is the timing. Specifically, they were exchanged during the Trump administration. So it's a little bit of an odd argument to make, given that the putative class representative was the president of that administration at the time. Now, the three complaints also dedicate a lot of space to the idea that Democrats were pushing for social media platforms to stamp out conservative voices. This pressure, according to the complaint, was put on particularly by Democrats claiming that they were going to reform Section 230 or reform various antitrust laws in order to make things more difficult for the social media platforms. But the problem with that is that Republicans have been doing the same thing, albeit for different reasons, including then President Trump. He signed an executive order geared towards limiting or maybe even abolishing Section 230 and notably held up a COVID relief package which had been approved by both houses on the basis of Section 230. He tried conditioning his approval of the second COVID relief package on the abolition or maybe limitation of Section 230, I'm pretty sure it was abolition of Section 230. But anyway, either way, former President Trump, while he was the sitting president, himself tried to limit Section 230. So it admittedly is a little bit of an odd argument to say that his deplatforming and the deplatforming of other conservative voices was because of pressure by the Democratic Party. But a little bit more on point. Although the Fauci emails were revealing as to the conversations between Dr. Fauci and Mark Zuckerberg, from what I read, I don't know that there is enough information in those emails to show that there's some sort of a conspiracy between Facebook and between Fauci and the CDC. And those emails seem to be the most revealing conversations as to Dr. Fauci and any social media platform that have been publicly revealed. So in my opinion, if those emails are the worst that exist, I don't know that that's going to be enough. Remember, what we'd be looking for in a case like this is that government actors are dictating specific content moderation decisions to the social media platforms. So far, I haven't seen that. More information could come out, especially in litigation. It definitely is not required that a complaint lay out all of the evidence that possibly exists. That's what discovery is for in litigation after all. So it is possible that there's information that isn't available yet. But if this is it, in my opinion, it's not enough. And because of that, we're back to the default rule for the First Amendment, which is that it can only be violated by the government. So now, what about this other thing that the complaint is asking for? The injunction declaring that Section 230 of the Communications Decency Act is unconstitutional. Well, Section 230 has been around since the mid-1990s, and there's actually quite a bit of case law on the subject. And not only have federal courts upheld Section 230, but they've also determined that the powers that the social media platforms and internet providers, generally speaking, are very, very broad. So in order to get a declaration that Section 230 is unconstitutional, there's going to be a little bit of an uphill battle. Just to give some numbers on this, in 2012, one court noted that there were 300 reported decisions on Section 230's immunity. And of those 300, only a handful were not given immunity. So in this case, without an extremely compelling reason for why it should be determined to be unconstitutional, it's going to face an uphill battle. So overall, the prognosis of these three cases doesn't look very good. But what do you think? Is there some information that I don't have that would change this analysis? Do you think Section 230 should be repealed or amended? Let us know in the comments below. Otherwise, I hope you found this interesting or at least informative. And if you did, I'd love it if you'd hit the like button. It really does help us with the YouTube algorithm gods.
What's this? What are you doing?
This isn't me.
I have been falling for 30 minutes!
And as I mentioned before, we're on a mission to our first 10,000 subscribers, so if you enjoyed this content and you want to see more stuff like this, consider subscribing and hitting the notification bell. That way you can find out when the next video is uploaded. See you in the next one.